Hello everyone. The Parliamentary Committee inquiring into suspended public protector Mkhwebane's witness to hold office on Wednesday shown court documents disputing her findings that CR17 campaign was implicated in money laundering. Evidence leaders at the Section 194 inquiry continued to unpack evidence Mkhwebane had presented to the Commission for 6 days. Mkhwebane has been unable to present evidence since Friday, after the Office of the Public Protector decided not to continue paying her for legal representation in the inquiry from April 1. In her report on the donation of 500,000 rands by African Global Operations CEO Gavin Watson to President Cyril Ramaphosa's CR17 campaign, the Public Protector said she made a finding of money laundering because the payment had passed through several intermediaries instead of straightforward donation to the campaign. Mkhwebane said she then referred the matter to the relevant institutions for probing. Evidence leader Nazreen Bawa SC presented excerpts from a Pretoria High Court judgment passed on March 2020, which reviewed and set aside the report. In the judgment, the court said that the Public Protector had no foundation in fact and in law to find that the president had involved himself in illegal activities sufficient to evoke the suspicion of money laundering. In addition, the Public Protector based her finding on legislation that has nothing to do with the offense of money laundering. The judgment also said Public Protector failed to properly analyze and understand the facts and evidence at her disposal. She clearly did not acquaint herself with the relevant law that defines and establishes the offense money laundering before making serious, unsubstantiated findings of money laundering against a duly elected head of state. Had she been diligent, she would not have arrived at the conclusion she did. Bauer said the court found that Watson had made a donation to the CR17 campaign as a long-standing member of the ANC. The court said there was no contrary evidence. The court also said Mkhwebane made serious findings based on an unfounded assumptions. Another evidence leader, Ncumisa Mayosi, said his remedial action on the CR17 report, Mkhwebane had directed that the National Director of Public Prosecutions, which is NDPP, within 30 working days, conduct further investigation into the prima facie evidence of money laundering she had uncovered during her investigation. Mkhwebane also said the NDPP must submit an implementation plan indicating how the remedial action will be implemented. This remedial action was challenged in court. Mayosi said what led to the challenge was that she did more than merely refer these matters to relevant authorities. She instructed the NDPP as to how to discharge her responsibility. What had to be determined by the court was whether the PP's remedial action was a mere referral or an instruction to those authorities. Mayosi read from the judgment setting aside the report, which stated that the remedial action directed at NDPP was an instruction. She said the Public Protector has no power to direct the NDPP when or how to carry out her functions, nor does she have powers to monitor the NDPP's conduct. That would undermine the essence of prosecutorial independence. What's your take on this one, people? Thanks for watching. Please subscribe for more news.